Hi, everyone. Thank you for joining us today. First, I would like to start by acknowledging and paying my respects to the Wurundjeri people as traditional owner custodians of the lands that I'm on today, which is our head office in Preston, and I pay my respects to the elders past and present. I also acknowledge that we are all on Aboriginal land across Australia. Sovereignty was never ceded. It always was and always will be Aboriginal land, despite any referendum vote. I'm Nerita Waight. I'm a proud Aotearoa Narrandjeri woman and the CEO of VALS and a member and treaty co-convener of the First Peoples Assembly of Victoria because one job's never enough. Thank you for joining us today. And much like other settler colonies, Australia has a really, really painful legacy of colonisation and dispossession that has deeply affected Aboriginal and Islander people for 236 years. People often think of invasion as the original sin, but generation after generation, decade after decade, all we're seeing is just perversions of the same aim, which is the eradication of Aboriginal people and culture. We are the only Commonwealth nation without a treaty with its First Peoples, and we now find ourselves at an important juncture of that history. Many of you may have joined today's discussion with the hope of answering the question, what will treaty actually achieve? Well, I'm sure each panelist here today will have their own contributions to this question. To me, treaty's acknowledgement of the need for healing, a recognition that the wounds of the past and present may be tended to if we want to create a more just future. And treaties about transforming the way that Australia operates so that everyone has a better life, not just the fortunate few. It's a pathway to ensuring better decision making for our communities. It's a fundamental recognition of our sovereignty, agency, and right to self determination. And through treaty, we can empower our communities to actively participate in shaping the policies and practices that impact our lives. Through treaty, we can lay the groundwork for dismantling the structures that have disproportionately impacted our people since invasion. While treaty will no doubt include a range of policy and legislative changes, it is most importantly about transforming the structures of modern Australia so that Aboriginal and Islander people have the ability to make decisions about our lives and the things that impact our people. And that our children, for me, I've got a 6 and 2-year-old, that they don't have the same experience that we've had, whether it be in the education system, in the justice system, in the child protection system. That these things change and they change in a way that is transformative, that ends overrepresentation, that produces equality, produces that actual fair go. Now, we know this process actually won't come without challenges. For a treaty to be productive, we need a commitment from the state to engage in negotiations in good faith and to honour whatever agreements are reached. This week, the Liberal and National parties announced that they are withdrawing support for the current process based on some rather vague concerns that were reminiscent of John Howard's campaign to undermine the Mabo decision and subsequent native title legislation. And the coalition parties made this decision based on internal discussions, apparently. They didn't discuss it with our communities or give us a heads up. And it's clearly not in good faith for a bunch of non-Indigenous MPs to make such a big decision about treaty without actually discussing with Aboriginal communities. And also, they might have waited till the process actually started. We saw last year how much damage can be caused when the Liberal National parties oppose reforms to give Aboriginal and Islander people a fair go. The relentless wrecking and scaremongering of the leader of the federal opposition and some of his colleagues not only torpedoed the referendum, but it amplified and emboldened the worst forms of racism in this country. In media and social media, at bus stops and local shops, in the workplace, our people were subjected to so much hate. And hate has a real impact. It means our children can't get the education they deserve. It means our people can't access the healthcare we need. It means we can't get the employment we have earned. It means we are over-policed and over-incarcerated. And ultimately, it means we die younger. This week, Peter Walsh and John Pesutto made the choice that our people should continue to suffer those impacts. If they are listening in today, my door's always open if they want to come and hear from community. I'm more than happy to put on an event here at VALS so that they can hear from us and explain themselves to us and maybe say what their solutions are. They need to do that if they want to participate in treaty genuinely. And we need them to participate genuinely because we're trying to create a better Victoria for everyone. In New Zealand, the new Conservative government is winding back many commitments made through treaty, and in Canada, there are many examples where traditional owner groups are rather frustrated by governments that do not live up to the commitments made in treaty. Victorian politicians, including the leaders of the coalition, often brag about how there is bipartisan commitment to multiculturalism in Victoria and how that bipartisan commitment contributes to what makes Victoria great. A bipartisan agreement to treaty would undoubtedly make an immense contribution to the social fabric of Victoria. Now, whilst they've withdrawn their commitment and their ability to work on this, I'll be working hard to make treaty work, and I'll be working with everyone who comes to treaty in good faith. I hope all of the leaders in Victoria will do the same. Today, you're going to hear from an amazing panel of First Nations leaders who have dedicated years of their life to advocating for justice for their own nations and who will share some real wisdom and insights from their own research experiences and learnings. First up, I'll welcome Dr. Carwyn Jones, joining us from New Zealand. Carwyn?
Tēnā koutou, ngā mihi nui kia koutou. Greetings, everyone. My name's Carwyn. I'm from Ngāti Kahungunu is my nation, and I'm a teacher in the Māori Laws and Philosophy program at Te Wānanga o Raukawa, which is a Māori tertiary institution. Kia ora.
Thank you, Dr. Carwyn. And we also have on the panel today is Andrea Hilland, KC, dialing in from British Columbia, Canada. Andrea, do you want to introduce yourself?
My name is Andrea Hilland. I'm from the Newhalk Nation, and my Newhalk name is Asit Samniak, which means carries a blanket. I'm currently located and working from the unceded ancestral territories of the Musqueam, Squamish, and Tsleil-Waututh people in Vancouver.
Thank you. And finally, joining us from home soil, so in Australia, we have Reuben and Berg. Reuben, do you want to introduce yourself?
Yeah, Nyatu Gunijmara, Nyatu Ndat Lingyong Reuben Berg. My name is Reuben Berg. I'm a proud Gunijmara man. I'm joining you here today from the lands of the Wurundjeri peoples, and I'm currently very privileged to be one of the co-chairs of the First Peoples Assembly of Victoria and getting to work alongside Nerita in that.
Yes, you're very lucky to work with me, Reuben. I agree. And lastly, just a content warning before we start. We will be discussing issues that will potentially include references to Aboriginal and or Torres Strait Islander people who are deceased and discussions of self-harm, trauma, violence, abuse, and racism. If any part of our discussion raises issues or concerns for you, we encourage Aboriginal and Islander people to call Yarning Safe and Strong, a helpline run by the Victorian Aboriginal Health Service on 1800 959 563, and anyone else can please call Lifeline on 13 11 14. Now on to the tough questions. Dr. Carwyn, for those who might not be familiar with the Treaty of Waitangi, could you give us an overview of its principles and what it means for the Maori people?
Sure. So the Treaty of Waitangi was signed in 1840 between leaders of different Maori communities and the British Crown. And so it was initially signed at a place called Waitangi on the 6th of February in 1840, which is it's north of Auckland. And then it was copies were taken around the country, and others were given an opportunity to sign. Now, so it has sort of been seen as a kind of national treaty in a way. And the treaty is quite short. It's got 3 brief articles, and the first article is a grant of authority to the British Crown. Now, in the Maori text, I should say that there's an English text and a Maori text, but the Maori text was the one which was signed by almost all the Maori who signed, understandably, and it was also the one that, in terms of the explanation and discussion which took place around it, all took place in Maori. So there are good reasons to view the Maori text as the kind of operative text of the treaty. The Maori text, the authority that's granted to the British Crown is the term that's used as kāwanatanga. Now, that word it actually comes from an English word. The base word is kāwana, and it comes from a derivation of the English word governor kawana. And kāwanatanga is all those things to do with the governor or government, so it's an authority of government. And the historians have sort of suggested that what was intended there was for Māori to grant authority to the British Crown to have authority over British subjects who were here in Aotearoa at the time, but not authority over Māori. And that's kind of reinforced by the second article of the treaty, which guarantees Māori authority, and the term that's used there is tino rangatiratanga, and that comes from the base word rangatira, which is the word for chief, rangatiratanga, those things to do with the chief or chieftainship, and tino is an intensifier, so it's all those special qualities of chieftainship or absolute chieftainship. We often talk about it as self-determination today. The third article is provides that Māori also have all the rights and privileges of British subjects. So it's a kind of equal citizenship clause, if you like. So that's the kind of basis of the agreement. As I say, it's sort of been understood as a sort of national treaty because copies get taken around, people get given the opportunity to sign. Not everybody does. And what's happened consequently is that the Crown for a long time largely ignored the treaty and certainly the guarantees of Māori authority. But from the 1970s onwards, we start to see the Crown using in legislation this term, the principles of the Treaty of Waitangi. So that's has become a kind of legal technical term, and the Waitangi Tribunal, which we might talk a little bit about in a moment, is required to look at both the English text and the Māori text to determine and apply these principles. So there's no definitive list of what those are, but the kind of key principles that the Waitangi Tribunal and the ordinary courts have come up with are things like partnership. So the treaty sets up a partnership between Māori and the Crown, active protection. So there's obligations on the Crown to actively protect those things which are guaranteed in Article 2, including that authority over all things that are highly valued, and that includes concrete, tangible things like lands and resources, but also things like the Māori language, or even Māori health and well-being, those kinds of things as well. And so the principles of the treaties have been a mechanism by which the courts have been able to give some teeth to the treaty, which otherwise is seen to be not directly legally enforceable through our domestic courts.
Thank you, Dr. Carwyn. And naturally, I'm now going to ask you that. Can you talk to me about how the Treaty of Waitangi operates across the two systems of law, so Māori law and English British law? And then perhaps if you could actually talk around the Waitangi Tribunal, because it's utterly fascinating.
Sure. So I think significantly, we ought to be thinking about the treaty as being established as the bridge between these two legal systems. So in 1840, actually the context of the signing of the treaty was really taking place within the Māori world, within a Māori legal and constitutional system. But of course, it's engaging with a British constitutional and legal system as well. And the written form of a treaty is a kind of new way of conducting these diplomatic relationships or establishing them for Māori. But what you see in the treaty is these two, the way in which the Waitangi Tribunal has described it off as these two spheres of influence or authority. So you have that authority that's granted to the Crown, kāwanatanga, the authority that's guaranteed to the chiefs, their own chieftainship or self-determination in relation to their own communities, tino rangatiratanga. And so you've got a situation where you have a public power effectively being shared between those two spheres of authority and influence. And the treaty provides a mechanism. It puts those two spheres of authority in relation to one another. So it provides a connection between these, if you like, the system of British law and constitutional thinking and all that goes with it, and Māori system of law and constitutional thinking and all that goes with it as well. And so that's the kind of vision, I think, that was set out in the treaty in 1840. And as I say, it hasn't really ever been fully lived up to. But what we have seen in recent years in particular is that the treaty's been an important kind of reference point for the courts and the Waitangi Tribunal to think about the ways in which Māori law might apply, might actually be considered to be part of New Zealand common law in some instances. And so that's an area that we've seen developing in recent years, that where where there are gaps in the common law, where there's no explicit statutory regime that says otherwise, that the courts will be entitled to look to say, well, what does Māori law have to say about this issue, and is it appropriate to apply in this in particular context? And part of that is to do with the Treaty of Waitangi, because it does provide that recognition of Māori authority in the tino rangatiratanga space. So that's sort of one area that's developed. But the Waitangi Tribunal was a body which, because the treaty by itself has not been recognised as having kind of direct independent enforceability, and that's to do with the fact that isn't, if it's considered to be an international treaty, then there is some requirement for there to be incorporation within the domestic legal system, within the New Zealand legal system, before it has any kind of teeth. And so some of the ways that that's happened is through this use of the term of the principles of the treaty in legislation, and so that provides a hook for the courts to engage with it. But one of the first kind of steps towards kind of recognising the constitutional status of the treaty, I suppose, was the establishment of the Waitangi Tribunal in 1975. And so this was set up to be a body that could hear claims based on the principles of the treaty. You didn't need to provide any other kind of administrative law test or private law test to have your claims around the principles of the treaty at least heard. And so the tribunal is set up as it's a commission of inquiry, and it's like a standing commission of inquiry. So it's been operating since 1975, and its jurisdiction is based on the principles of the treaty, and it's required to make findings and recommendations about the application of those principles to government. So as a commission of inquiry, it doesn't, by and large, make binding recommendations. It only has authority to provide recommendations to government that government can then choose to either adopt or ignore. The tribunal, when it was first set up in 1975, it only had jurisdiction to deal with kind of contemporary issues, allegations of treaty breach by the Crown relating to things that the Crown had done from 1975 onwards. But in 1985, its jurisdiction gets extended into this historical space back to the signing of the treaty in 1840. And of course, that's actually where most of the breaches around taking of land or loss of control of natural resources takes place. So for a large part of the tribunal's life, the tribunal was very much focused on these large-scale district inquiries dealing with land loss and associated issues. But it's always had the ability to look at contemporary policy type questions, and some of its most significant reports have included things like its report into the Māori language in the 1980s, which led to the Māori language being adopted as an official language here in Aotearoa. And actually now, the tribunal no longer has a historical jurisdiction. It is only focused, it is still completing some of its historical claims, but is working to complete those, and is turned its focus much more to contemporary policy issues. So we have some ongoing inquiries around Māori health, around there's a constitutional inquiry just beginning. There's an inquiry about mana wahine, which is about Māori women's rights, and so contemporary sort of thematic issues there. The members of the tribunal, the legislation sort of says that the membership should reflect the partnership of the treaty, which has generally been taken to mean that there should be roughly the same number of Māori and non-Māori on the tribunal at any one time. And the tribunal, they don't all hear all the claims all together. They often hear them as panels of 3 or 5 members, as sort of usual numbers, and it's made up of people with all kinds of relevant expertise. So there are people who are judges or who have legal expertise, people who are experts in Māori language, culture, history, other kinds of historians, and people who have backgrounds in public policy or business or other kinds of matters which might be relevant to the tribunal's jurisdiction. And so they hear inquiries, report on them, provide findings and recommendations to government.
Thank you. That was really informative. And it would be remiss of me not to ask considering that Victoria is going down the path of treaty, what would be the 3 things that you would want First Nations communities to remember as they walk through that process?
One thing would be to think about the monitoring mechanism and what kind of mechanisms you're going to have for accountability and to ensure that the terms of your treaty are adhered to. The other thing that I think has been really important in terms of the Treaty of Waitangi, but also as we've moved through some of our settlements of historical breaches and included in those agreements, is to think about the ways in which you might appropriately reflect concepts from our own law and legal systems and to think about the language that's going to best capture that. So I think the fact that in the Treaty of Waitangi that the Māori language, that there is a Māori language text and that those concepts of tino rangatiratanga in particular are used and essential is important. And I've seen in some of the settlement agreements in relation to thinking about, for example, how a particular nation relates to their river, they've drawn on their own traditional statements about how they see that river and put those into the legislation to be the guiding principles for those. And the other thing I think that has been and is still a real issue for us moving through the settlement of these historical treaty claims is these questions of mandate, about who gets to speak and at what level these issues are agreed to, and I think that that's an issue which is really worth spending a lot of time on. It does take time, but I think there's real value, again, thinking about our own processes for how we would normally work through determining questions of who gets to speak and who has a say and all those kinds of things, and making sure that we're working to our own processes rather than fitting into necessarily a framework that's determined by government.
That's great advice. I'm thankfully going to give you a little bit of a break, Carwyn, and probably until question time because I'm sure it's going to hit you hard. But now moving on to some questions that I have for Andrea. Could you give us an overview of the evolution of treaty making with First Nations in Canada?
Yes, I could do that. I'm just going to share my screen. There were a number of phases of treaty making in Canada, and the initial treaties were actually just peace and friendship treaties. So agreeing not to war with people who were coming in, the settlers who were coming to trade. And that was in Maritimes on the East Coast. So that's to the right of the screen, in the 16 and 1700s. And then as treaty making moved westward, and initially treaty making was very much a nation-to-nation arrangement, and it related to peaceful coexistence and non-interference. By the early 1800s, there were small kind of cession treaties that were started to be made. So this is where land transfers start to come in. And then in the 1850s, the Robinson-Huron and Robinson-Superior treaties became the template for numbered treaties. And then as treaty making moved further westward, and this was largely in relation to the development of the cross-continental railroad, the numbered treaties were really focused on surrendering land. There was a lot of exploitation and a lot of creating circumstances of duress to get people to sign treaties. So those are the ones that have numbers like 1, 2, 3, 4, like all across. So as you get across to the number 8, and it says 1899 there, that starts to creep into British Columbia. But mostly what happened in British Columbia is that the Crown ran out of motivation and money to negotiate treaties. And I think there was a sense that Indigenous people were a dying race and eventually would just be either absorbed or extinct. And so no treaties were required. This obviously is not true. I mean, I'm here. And then in 1973, the Niska Nation, which is seen on the map as well on the left side, they took a title case. and it went all the way to the Supreme Court of Canada, who didn't actually decide whether or not there was title there, but decided that there may be title there. And so that kind of triggered a modern day treaty process. The Nisga'a Nation negotiated a treaty kind of under a separate process, which was called the Comprehensive Claims Policy. And their treaty was finalized in 1990. Kind of from that, the BC treaty process emerged. And the BC treaty process was not a nation to nation. It brought in the province to create tripartite treaty negotiations. And initially, First Nations in British Columbia wanted it to be a nation to nation negotiation. They didn't want the province in there because the province was, and still is, just issuing licenses and extracting resources. So part of the treaty process required that the province be involved. The other thing was that First Nation sovereignty was not on the table. Any acknowledgement of self-government or self-determination was watered down to be kind of a municipal style government through the treaty process. And then to participate in the process, First Nations had to agree not to litigate against either crown through the duration of the negotiations, which have been decades long now. And in the meantime, the crowns can still issue permits that are affecting Indigenous territories. So the government also had a formula, which I believe was loosely based on per capita. So the cap was 5% of land back, that roughly correlates to the population of Indigenous people in British Columbia. But I mean, from the Indigenous perspective, flip that, like we're being asked to give up 95% of our territory. And then there was also a fire mentality to the process, because Indigenous people see their resources like going out by shiploads and tankers full of stuff. And it's, the government is at the negotiating table saying, you need to get something because we're taking it anyway and you're going to get nothing. So that was heavily influenced the process itself. And my colleague, Johnny Mack from Allard Law at the University of British Columbia, he writes about, because his nation signed on to the Manil Treaty, and he talks about it as if a canoe flipped and everybody was scrambling to get back on, and there's completely disorientation and panic. That's how he feels about the treaty that his nation signed on to. The other thing about the BC treaty process was that the funds that were used to negotiate by the Indigenous people would be subtracted from their settlement. And you could exchange for land, right? So you're talking decades worth of negotiations with high-priced lawyers and consultants. And at the end of the day, where's that money coming from? You eventually have to pay it back, and you might make concessions to your territory, to remove your debt. There's also, and I experienced this, very personally with the New Hulk Nation, that there's a requirement to establish hard boundaries as between the First Nations. And I don't know how much this would affect your First Nations in your respective territories, but in British Columbia, there are a lot. So I've highlighted there, my nation is highlighted in yellow, and then the Nisga'a Nation is also highlighted as a little further north of New Hulk territory. But the BC treaty process required you to set firm boundaries when our Indigenous legal traditions have intermarriages and have very nuanced laws around sharing territories. And so that was not accepted in the BC treaty process, and that has caused a lot of issues between First Nations. And just an update that the Gitxsan are challenging the Nisga'a Treaty boundary, and so this was just decided in January, so earlier this month, that the Niska will be represented by Canada and British Columbia and do not have a party status at the port. That is very paternalistic, obviously. The colonial governments are going to handle how that boundary is resolved. So that's the situation with the treaties that have been negotiated under the BC treaty process. Just as of 2019, the provision regarding payback of loans has now been removed. And there's a little bit of acknowledgement of the possibility for self-government, but I think that is very much within the colonial sense and not from an Indigenous perspective of what that means. So that's where we're at now.
No, thank you. That's so helpful. And I suppose that's like a double question in a sense, but I'm just wondering if you could explain sort of what your own nation's objections are to treaty making, and then kind of what alternative mechanisms do you see beneficial to strengthen and uphold your nation's rights, if not treaty?
So I think it was obvious that there are a number of problems with the existing treaty process, that my nation was always opposed to the process itself. I think the main reason that the Newhawk are not interested in the treaty is actually it relates to our spiritual connections with our territory. So each Newhawk person has a name that ties to the territory, and there's an understanding that our existence as people in the present day is only a connection between our ancestors and our future generations. So we're very humble. We don't believe we have the right to sever the connection, to freeze any relationship in time to our territory. And so one quote that I wanted to share with you is my great-grandmother Margaret, whose Newhawk name is Sisinai. She had this saying that the colonizers have only been here for a blink of an eye compared to the length of our history and our connection to our territory. And we need to be patient and strong in who we are, and not to give that up, not to not to get disoriented, not to like panic, because things change all the time. And I just think of, she was born in 1895, I believe. That how big of change since she was alive, and she passed away in 1985. She gave me my Newhawk name, my ancestral name, so I knew her, and just she would rather pass on the struggle and the Newhawk mindset about our territory and how close and connected we are than to surrender that. So I think that's largely what our position is on treaties. And then you had also said what other strategies have we used? Treaties would lock the Newhawk people into the colonial imagination as well, right? That they can't even conceptualize what Newhawk law is and how it is so much more nuanced and better at dealing with the ecosystems and everything else. So like we need to protect that first and foremost and pass that on to the future generations. The ways we do it pragmatically is actually to cause trouble. And I'm saying this as a lawyer. I practiced for 20 years. I became King's Counsel, but I still, I really am influenced by Newhawk law and doing whatever we can to stop extraction from our territory. My uncle, late uncle Quatsinas, he was known around the world for blockading or defending our territory from logging. And the hereditary chiefs back in the late 1990s, so this is just when I was starting law school, they were touring Germany, and they had done markets research to find out who was buying the logs from our territory, and they found out that it was Germany was buying a lot, and so they brought delegates from Germany to come and look at the territory to see what's happening on the ground, and they also went to Germany themselves on a totem pole tour, and so they were carving a totem pole and stopping at different places to explain the importance of the logs to the Newhawk people and how that was affecting our use in our territory. So that was one that was like an educational campaign, and blockades, and the hereditary chiefs who blocked the road and stopped the logging were sent to jail. But eventually from that came the Great Bear Rainforest Agreement, which is more of an ecosystem-based management. And again, I still am hesitant to endorse that completely, just because it's, it tries to incorporate Indigenous laws, but it's not Indigenous law. And trying to hybridize with provincial laws, for me, just doesn't feel authentic or true to what Newhawk law is. We've also, with the logging issue, made submissions to an international trade body and argued that there is a subsidy for Canada not having signed treaties, not having compensated the Indigenous people for the logs or the land. And we were successful in that. And so we had a tariff put on to Canadian lumber. And then international, we often make international submissions to different UN bodies and to Amnesty International, whatever we can do to kind of raise the profile and raise the issue that Canada's not this glowing, benevolent country that they're still very much exploiting. I think it comes through, the wet sweat and protests, I think, are known internationally about the pipeline going through. So we stand in solidarity with our other First Nations who are also exerting their inherent jurisdiction.
And I have one last question, which is what piece of advice would you give to First Nations communities here in Victoria who are walking the path to treaty?
There's a lot of cautions, right? I think why is the other party involved? What are they trying to get from you? In British Columbia, it's been they want the land. It used to be the language was cede and surrender, and now it's certainty, but they're talking about economic certainty, and they're talking about they don't want Indigenous people blockading the road, right? That's what it's about. So what is the motivation? And then do you trust that this is a good place to set things in stone, right? And considering my great-grandmother Sisinai's instruction that, how far behind you and how far ahead of you do you need to look? And a treaty is only as good as it is interpreted, right? That's another thing that I wanted to mention, and so thanks for raising that. In the Treaty 8 area, so that's in the species map here, the Dene Da and Dene Za, they are party to Treaty 8, and there have been, this is oil, and it's not oil, it's pipeline, it's fracking territory. Their treaty has a taking up provision which allows the province to take up land for infrastructure, resource development. I believe it's only 8 kilometers left where they can exercise their treaty right. Even though they have a treaty, in Canada, treaties are still subject to consultation and accommodation, so you can justifiably infringe them. So I would say signing a treaty is not the end all and be all. You have to think about how it's going to be interpreted. You have to think do you trust the people that you're signing with enough that it means anything? I think that's a very real threat. What's the motivation? and what are you actually protecting, and what are you actually giving up. And I speak a bit, Canada's unique in that it has Aboriginal rights, and treaty rights are protected under the Constitution as well. And so for the Newhalk Nation, we could take our issues to court under the Section 35 protection. My experience with that as well is that that doesn't protect everything, right? Like you still have to fight for everything.
No, thank you. It's great advice, and certainly really kind of an opportune time to receive it, given what's gone on recently. So thank you, Reuben. It's been a rather interesting week for state treaty discussions. Where is Victoria currently at with the treaty process, and what are the potential implications of the Victorian opposition withdrawing their support?
Yeah, great questions, Nerita. I would say that from my perspective, that the treaty process in Victoria is actually in quite a strong position where we are at the moment. That's in particular because we've had already some really powerful agreements made around the process for treaty. We're still in there's a long way to go in terms of negotiations, but in terms of actual process for treaties, we've already got in place some really strong agreements that have gone through Parliament that did have bipartisan support previously. And so those elements that we already have in place, the Treaty Authority, which is an independent umpire that's now been established to oversee the treaty process to make sure that all parties who come to sit and negotiate are actually following the proper processes for negotiation of treaties. We have the Self-Determination Fund that's been established, which is there as a priority at the moment to support traditional owners who do want to come and negotiate their own local traditional owner-based treaties, to have the resources they need to begin those conversations within their communities. So that's already in place. And we also have agreement with the state around the treaty negotiation framework, which is essentially the rule book about how we're going to go about undertaking treaties. We've also moved from the Assembly in its first phase, which was very much about setting up a process for treaties. Now, post our elections we had 6 months ago, we're in the next phase of the Assembly, where now it's the Assembly's responsibility to actually sit down and negotiate statewide treaty outcomes with the state government. So we are in a really strong position. Obviously, if you could, in an ideal world, we'll be having these conversations with bipartisan support because it just makes things a little bit smoother. But we do have all the things in place to continue to sit down, and we have a government that's really keen to sit down with us and have really positive conversations around treaty making. So from my perspective, we're in a really strong spot.
Thanks, Reuben. And in the past, you've said that both yourself and the Assembly remain hopeful for the future of treaty in Victoria, and nothing from what you've said today seems to dissuade against that. But I'm just wondering, for you, what are the ideal outcomes for both a statewide treaty and a traditional owner treaty, just noting your own experience with both?
Yeah, when I think about what the aspirations are, the long-term aspirations, is that treaty provides an opportunity for both at a statewide level and a local traditional owner level for self-government, for First Peoples, whether that's at a statewide level or traditional owners at a local level, to be able to take control of decisions that directly affect their communities. And so at a local traditional owner level, that's about decision-making to do with land and water and heritage and language and cultural protocols. Those are things that hopefully through treaty, traditional owner groups are empowered to be the decision makers on. And at a statewide level, that flows across to a variety of different things that have direct impact on First Peoples. There's also going to be a really important role through treaty of the government's still going to have responsibilities. Nothing about treaties saying that all of a sudden there's an entirely new bureaucracy that's entirely made up of First Peoples. The government is still going to have responsibilities. So treaty provides an opportunity to hold government accountable to their obligations and to make sure that they're actually fulfilling their requirements through that. So those are some of the aspirations from my perspective around treaty, that the changes we want to see, the decisions we want to see made to improve our lives, that we're empowered to make those decisions. We don't have to lock those in through treaty. Treaty is a mechanism that we can be in charge of that as First Peoples for things that affect us.
Thanks, Reuben. And kind of a two-parter. One is that not everybody is familiar with First Peoples Assembly of Victoria, although if they're in Victoria, they certainly should be. So wondering if you can sort of explain the structure and how it reflects cultural structures of authority and governance, but also kind of what are you actually hearing in terms of consultations across the state over the last few years?
Yeah, so the first People's Assembly of Victoria was first established back in 2019 after lots of ongoing discussions and negotiation, which was led by Aunty Jill Gallagher in the commission that was before the Assembly. And the Assembly, really important to know, is it's an elected group, a democratically elected group of Victorian traditional owners. And there are two different ways that people become members of the Assembly. There is a broad election process within different regions, and the regions are set up so that there's reasonable representation of the population within each of those areas. First Peoples within those regions get to vote for their representatives, and there is a gender quota around the representatives from each of those regions as well. And that gives us 21 of the members within the Assembly. And then the additional seats then come from those traditional owner groups who already have some form of formal recognition by the state, whether that's through native title, through the Traditional Owner Settlement Act, through the Registered Aboriginal Party process. Those groups who have formal recognition, they're enabled to select a representative from their community to sit also on the Assembly. And one of the powerful aspects of that is that the Assembly doesn't in any way dictate how those groups get to decide who their representative is. It's a self-determined process by those groups. So that's how I've been selected. I'm a representative of Eastern Maar, and we went through our own particular process, which was different from other groups, to select me as their representative. And that's a really important aspect of that cultural governance, in that each particular traditional owner groups gets to self-determine how they want to select their representative. There are other aspects of how we structure ourselves as the Assembly. So once we're all on board as members, the 32 of us, we then establish various processes to how we want to go about doing our business. And one of those is that we have various committees which all members of the Assembly can participate in and be part of. And we have a dedicated treaty committee, which focuses on progressing the work of treaty and negotiations, which we're very lucky to have you, Nerita, as one of the co-conveners of that. But we also have a Yerpa committee, which talks about our cultural business, our cultural governance, about how we want to go about doing things our way. And that's another committee that all of our members are a part of. We also have an elders voice, which is made up of two of our representatives from the Assembly, two of our elders that we choose to lead that elders voice. And we're in a process now of going out to have a standing group of elders from the broader community to be a part of that and feed advice and input and guidance to us as Assembly members. And we have a dedicated youth voice as well, where we've got some of our younger members of the Assembly out there trying to make sure we engage and hear the views of young people. And so there's a variety of different ways that we go about trying to make sure we do our business in a culturally appropriate way. Through all of that, across the many years we've been doing this now, we have had many different conversations with community about their aspirations around treaty. And a lot of that we've been able to incorporate along the way in terms of how we have set things up and how we put in place the treaty authority, the fund and the framework. The consistent messages that I hear from community is that we just want to have an opportunity to make our own decisions about these things. We want to find some mechanism to get government from stop interfering in our lives. We've seen the impacts of what happened when government are in control of certain things and we don't get the outcomes we think we know we should be getting. And so the strong message I hear from communities, let's make sure we can find a way that we can be in charge of decisions that are going to directly affect us. And we need to do that in a way that both honours the important work of our elders and our ancestors beforehand, recognises their amazing work and their legacy, and kind of make sure that the elders we do have now get to realise some of those aspirations, but that we also do so in a way that makes sure that for future generations, things are set up for them to succeed as well. So those are some of the messages I've been hearing.
No, thank you, Reuben. That's really useful. And, I can't help but take advantage here and just note that, we're in our 50th year. We've seen so many changes over that time, and led by Aboriginal leaders like your dad, who was a founding member, actually set up VALS. And I'm just wondering, can you actually talk about how perhaps the legacy of those earlier generations of Aboriginal advocates, whether it be your dad, whether it be Sir Pastor Doug Nichols or William Cooper, how that actually informs your own approach to treaty?
It's always important to reflect and recognise those important people who have gone before us and done amazing work to get us to these positions. And the biggest thing that I draw from those past, and Dad's still there giving me advice today, I get to catch up with him and the grandkids whenever I can, is that when we are having these sorts of conversations, when we're trying to work out what it is we're trying to aspire to, and it was really interesting listening to what the other speakers were talking about, as well as some of the things to be mindful of, is that we can never lose sight of our principles about what we think is actually important to us as a people. And there's no element of treaty that's worth compromising our principles on to get that. And that's one of the things I absolutely do draw from the lessons and learnings from people who've gone before.
Thank you. One question that's come through, and I think because we have on this panel some really differing views on the utility of treaty, it would be interesting to answer. There's a perspective that treaty is a generous gift from Indigenous people to settlers, and that often you see Indigenous people advocating for treaty when it gives settlers an opportunity to be in the right and honourable relationship with the lands and its people. Just wondering if anybody wants to reflect on that viewpoint.
Yeah, I think it's a really strong point to be made there, that it is true that often what we hear about advocates, and not all First Peoples advocates around the benefits of treaty, but it often comes from a First People-led initiative. But I think it's absolutely true that there is benefits to be brought for the broader community from that, and there needs to be strong recognition of that. And that's one of our things we're going to have to consider moving forward now that we don't have bipartisan support, is how to make sure that that message is understood. And I think there is an obligation on the broader non-Indigenous community to really think about, from their perspective, what are the benefits for treaty for them, because it's not enough to necessarily for political goodwill to say, yes, we think treaty is a good idea because of First People say so. It's being able to articulate why is it that for non-Indigenous peoples, why they see the benefit of treaty beyond just because it benefits First Peoples. And I think there's a raft of positives that sit behind that, but I think that's something that the broader community need to be able to articulate themselves, and that's a really important question to ponder.
I think I had mentioned just in Canada, the initial treaty making was nation to nation, and it was First Nation people kind of sharing their territory, but with the understanding of non-interference and the understanding of their own self-determination to continue to live as they had formerly. And again, using the metaphor of looking to the past and the future, a lot of the treaties contain language, that said, as long as the rivers flow, and that kind of language. So the treaties are the basis of Canada's existence on this continent. So Canadians who are not Indigenous people have a treaty relationship with the treaties. Like, that is their permit to be on the continent. In British Columbia, we don't have that yet for most of it. And I think just the evolution has changed it so much that it's now so extractive, and it really needs to shift. And I think the changes that I mentioned in 2019, where the BC treaty process was modernized and some of the more offensive, aggressive cede and surrender language was taken out. I think the fear, though, is that the mindset is still there, that's still they're wanting certainty, which means they want access to our resources. And I think that is exploitive. I think there is a possibility to have, more equal kind of treaty making. But what we have in British Columbia right now is not.
Certainly the Treaty of Waitangi was about carving out space for the British Crown to exercise some authority. So, certainly my understanding of it is that it's very much is about providing a legitimacy for the exercise of government within the framework that allows for continued Māori te no rangatiratanga or self-determination or authority to continue and be maintained. So in that sense, I think it is very much about a benefit for the settler population here to have a kind of legitimate grounding, a basis of government that comes from this moment of consent. I think is really powerful. And also today, I think it provides a really useful framework for thinking about how we engage in a whole lot of the issues that are confronting us. I think climate change in particular is one that we're going to be required to think about how we bring in different voices, how we work from different systems of knowledge to address the problems created by climate change. And, something like the Treaty of Waitangi, I think, provides a really good framework for setting out how you can move across different spheres of authority, think about drawing on different expertise, different knowledge systems, having different voices and decision-making processes to make that work and to address those issues that we're all trying to deal with.
The next question, I think, is something that, for me, working at an Aboriginal legal service, is at the forefront of our minds, which is the over-incarceration of our peoples. Sure, it's no secret to anybody that over-incarceration has continued to rise. Certainly in my lifetime, so 36 odd years, things have gotten worse, not better in that space. And there's a real question in the comments whether or not treaty could actually address that over-incarceration. And there's also a comment around how, and I'm hoping, Andrea, you can help out here, that apparently in Canada, there are self-determined child and family services that are funded and separate to provincial governments as a way to stop the state from taking Indigenous babies. So do these kind of separate processes actually work in reducing over-incarceration and over-representation in child protection, or are there other things that we should be thinking of?
I'll start just by jumping in and explaining that the child welfare legislation has nothing to do with the treaty process at all. It arose because the federal government was underfunding child welfare services to First Nations children. And so that it, like, numerically could show that there was something like a 60% underfunding. So the Child Welfare Family Society took Indigenous children, took the case to the Federal Human Rights Commission and won again, and had to go back and get an order for the federal government to pay. And so it's been quite an embarrassment for the federal government. And so again, it's litigation. It has nothing to do with treaty, where Indigenous people are using the courts to get things, but it's not related to treaty. And so that's where the legislation came from. And I'll say also that it's basically a delegated authority at this point. There are still certain colonial standards that have to be met to create your own legislation about it. You might be able to include some Indigenous aspects, but it is essentially, it's still the colonial structure, and maybe a little bit friendlier to Indigenous people, and having Indigenous people kind of tweak the colonial structure and then endorse it. That to me it's quite different than true Indigenous laws about families.
It sounds a little bit like what we have in Victoria here, where it is still the colonial system, but there are sort of tweaks to allow for Aboriginal involvement. So there's things like Koori Hearing Day, where all the Aboriginal matters are listed on one day, and people sit around a table versus being in an adversarial setting, or where they can provide advice to the department on placement, but really it's not a self-determined system in any way, shape, or form, as I'm understanding what you've said. And again, those things have, for Victoria, come out of the kind of struggle on kind of advocacy and strategic policy versus the road to treaty. Dr. Carwyn, I wonder if there's any relevant examples from New Zealand around how treaty has positively affected outcomes in overrepresentation and both in child protection and in criminal justice.
Yeah, so we had some recent changes to our child, youth and family legislation, which mandated the kind of building in of partnerships with iwi, so different Māori nations, and that's and that was sort of based around a kind of treaty principles provision. So it was explicitly linked back to the treaty, but that's one of the measures which the new government is removing, so barely got off the ground really. What we have seen in some of the settlements of historical treaty claims is that these settlements often include new kinds of relationships with government agencies, and some I think that being effective in this kind of area are ones which again have explicitly included Māori concepts and understandings within those settlements. So one of the ones I think is quite important is in the Tūhoe settlement, where they have a range of relationships with social services agencies, and part of their agreement is that they have got the government to acknowledge that the government will take into account the Tūhoe understanding, so the Māori nation's understandings of the concept of whānau, of what we would think of as an extended family, and the role that plays in the delivery of social services. So I think that that kind of thing can be really effective in helping to shift us into a better space, particularly in terms of some of those child protection kinds of issues as well. But the other matter that wasn't specifically linked to the treaty, but I think sort of comes from that context too, is the cultural reports, which have been in recent years have been effectively used in terms of sentencing and often providing for discounts in sentencing. They're not specifically for Māori, but often used in that context to talk about the particular cultural context. But again, that's something that the new government is going to be removing funding for the production of these what are called cultural reports and sentencing. So some things which have been in play, which might have seen some positive results coming through, but are in the process of being removed.
I feel you. Here at VALS, we've got a pilot project called Aboriginal Community Justice Reports. So they're very much reflected on Gladue reporting in Canada and considered about how it might be improved for Aboriginal outcomes here. And it has been so pivotal to really great outcomes for our incarcerated mob, but also, most importantly for me, it's also not just about the sentence, it's about their safe transition out of incarceration and them staying away from that system from good that has been most impactful. So I really send all my sympathy for whatever it's worth to New Zealand mob at the moment, because you're going through a really, really difficult and shitty time. So Reuben, tell me, lastly, how are you going to fix all this through treaty and when you're going to do it?
Yeah, thanks, Nerita. Look, I think there's two broad ways that I think treaty can have an impact in this space. One is that the broader aspiration of treaty is to build wealth and prosperity within our communities and to build stronger empowerment within our communities, enable us to have greater pride in our culture and greater sense of confidence and ability to just live our lives the way we want to live our lives. And I think that in a broader sense is one way of addressing some of these concerns. In a more practical and immediate sense, we alongside all the work we've already done as an assembly, we have the Yuruk Truth and Justice Commission that has been established, and they've been doing particular work looking into the areas of child protection and criminal justice, and there's been some powerful recommendations that come out of that, and the treaty process is set up to ensure that those recommendations are part of treaty negotiations. And so the way that we're going to be moving forward on that is to work with our experts in our communities on these areas to understand what are the changes that we can make and implement through treaty to transform some of these systems so we can address these really important issues. So I think there's two kind of ways that we're able to tackle that through treaty.
Thanks, Reuben. I see you successfully dodged the when, but certainly gave us some really interesting ways to think about how it can be done. I think the important thing to remember, particularly for Victorians who are listening, is that we can't do treaty without you, without your perspectives, without your input. So it's really important that you get along FPAV events. You can sign up to their newsletter, go on their social media, and you can engage with members directly for your local area. So please do that because we want to get everybody's best skills, best viewpoints, and even our international counterparts who have been so informative throughout this process and will continue to be so into the future. A big thank you to our panelists today. Couldn't have asked for a better bunch of people to be talking through this, and you've given us all plenty to reflect on. Thank you everyone for joining us today. It's encouraging to see so many people engaging with such an important topic. And I encourage you to continue having conversations about treaty and justice beyond this space. If you'd like to support the work that VALS does, you can make a donation at vals.org.au/donate. Last year, you received over 15% of our online donations for the year on Invasion Day, so we would really appreciate it if you or your friends and family can make a donation too, because that's how we support families who've lost loved ones in custody, even our incarcerated mob who need a train ticket home. That's how we do that. And also a reminder that if today's discussion has raised any issues or concerns for you, please use Yarning Safe and Strong, a helpline run by the Victorian Mental Health Service on 1-800-959-563, and anyone else can call Lifeline on 13 11 14. Thank you all and goodbye.